Deep into a case that exposes some serious cracks in Virginia's child welfare process. And it's not just about paperwork.
I've seen firsthand how these cracks turn into chasms. I'm here as the director of Jaemi nonprofit, sharing my story and the stories of so many friends and relatives of abusers. And joining us is the Constituent Services Consultant from the Adoption Program at the Virginia Department of Social Services.
We're going to unpack the timeline of a prolonged CPS case, discuss legal requirements that were missed, and examine the human impact on families and children. By the end, you'll know why urgent intervention matters and what steps can make a real difference.
Here's our roadmap. First, we'll walk through the case events, then highlight where the system broke down, discuss state and federal legal obligations, and finally, talk solutions including oversight and advocacy. Let's jump right in.
I keep coming back to August 2023, a child taken into custody by PDSS. Over the next months, meetings, complaints, and appeals piled up, but the core issues just lingered. It's like every procedural step took twice as long as it should.
Absolutely, those delays created real harm. The parent partnership meeting happened, complaints went to the Attorney General, and then the OCO, but it took almost a year before any administrative disposition was issued. And even then, the notice of appeal and confirmations dragged on for months.
Fast forward to 2025, and only then did the court order supervised visitation. That's almost 2 years after the initial removal while visitation finally began. The family had been separated for ages. That delay isn't just an inconvenience. It's a fundamental failure.
The consequences go beyond legal paperwork. These kids and their parents are stuck in uncertainty with missed milestones, lost memories, and fractured bonds. It's a timeline where every missed deadline had a ripple effect on lives.
What stands out is how many legal duties were simply ignored. Emergency removal under Virginia Code Section 16.1 to 251 is supposed to require clear justification, a child's actual danger, not just vague concerns. But the evidence didn't match the severity of restrictions imposed.
And the procedural due process under the 14th Amendment was at risk, too. CPS workers refused recording meetings, failed to make required home visits, and didn't interview key parties. That's not just poor practice, it's a violation of both state law and basic fairness.
Even the statutory timelines under Virginia Code Section 63.2 to 1505, determining within 45 days if a case is founded or not, were neglected. This case stayed open for years, without proper closure or explanation, which is a clear breach of duty.
When the system doesn't follow its own rules, families lose trust and kids lose stability. It's an issue of legal compliance, but ultimately, it's about accountability and child welfare.
The harm wasn't just from delays. There were lost records, denied duplicate files, and mailing errors. Those procedural failures meant families couldn't even properly prepare for appeals, sometimes for years.
Exactly. And when records are lost or access is denied, it disrupts the entire appeals process. Under Virginia Code Section 63.2 to 1526, parents have the right to meaningful participation, which includes timely access to their case files. Without that, the appeal is almost impossible.
Then there's the question of purging records under Virginia law. If files aren't properly maintained or expunged when appropriate, inaccurate findings can linger and damage reputations and futures.
It's more than administrative error. It means families spend years separated, unable to reunify, simply because paperwork wasn't handled correctly. That's procedural harm with real emotional costs.
It's tempting to chalk this up to a single bad case, but the data says otherwise. Virginia ranks 49th for youth aging out of foster care without permanent connections. Oversight bodies report widespread procedural failures and bias.
The problem is structural: state supervision, local administration, and gaps where accountability slips through. Other states, like West Virginia, brought in court-ordered oversight and saved lives by tightening procedures. Virginia needs that same urgency.
What's really needed is district-level intervention and consistent enforcement of laws. No parent or child should be left vulnerable because the system failed to act. Stronger oversight could close those gaps and protect families.
And supporting structural reforms, means ensuring procedural protections are enforced, not just written. That's how we start moving from crisis management toward real prevention and healing.
So, what can families and advocates actually do? One powerful step is pushing for independent oversight. State-appointed or third-party monitors can shine a light on systemic failures and force improvements.
Advocacy goes hand in hand with requesting audits of timeline compliance and corrective actions. Parents can demand written explanations for missing records or delays, and ask for expungement of inaccurate findings under the VA CPS appeal process.
If administrative remedies fail, judicial review under Virginia's Administrative Process Act is an option. Families can pursue expedited reunification reviews, ombudsman intervention, and challenge delays through the courts when necessary.
Every step helps break the cycle of indefinite limbo. By staying persistent, families can push for transparency, accountability, and ultimately, safe reunification. It's hard work, but absolutely vital.
Let's wrap up with some key takeaways. First, procedural failures aren't just technical. They have deep emotional and legal consequences for families. Second, oversight and enforcement are essential to fix these gaps. Third, advocacy and persistence can drive change, even against entrenched systems.
If you're affected or know someone who is, start by demanding written explanations, requesting audits, and pursuing appeals. Document everything and reach out to oversight agencies. Don't let the system's failures become your family's future.
The next practical step: connect with local advocacy groups and push for independent oversight at the state level. Even one voice can spark a movement. Thank you for joining us, and let's keep holding the system accountable together.
Your story matters, and change is possible. Until next time, stay informed, stay strong, and keep advocating for families in Virginia.